A quiet hallway. White fluorescent lights. A steel door that closes with a sound so final it feels like time itself has stopped. At San Quentin State Prison in California, there was a moment that became known to many staff members as the beginning of the end, the last walk. Not a dramatic scene. Not chaos. Just footsteps echoing down a corridor built to separate a man from the rest of the world forever. For decades, San Quentin held the largest death row in the United States. The prison became a symbol of capital punishment, where hundreds of condemned inmates waited, sometimes for decades, for a sentence that might never come. Some called it justice. Others called it a slow, uncertain form of punishment. But the question remains, what really happens inside a system where the state prepares for death, while time keeps stretching the sentence into years, and sometimes a lifetime? This documentary explores the real, verified history of San Quentin State Prison's death row, one of the most well-known and controversial death row units in American history. We will examine how San Quentin became the center of California's execution system, how death row functioned over the years, and why the process of carrying out executions became slower, more legally complex, and increasingly debated across the United States. This story is based on publicly documented facts, including official records, court rulings, historical reporting, and criminal justice research. It is presented for education and public understanding, with respect for victims, families, prison staff, and all those affected. This is not a story meant to glorify crime or criminals. It is a factual look at a system that has shaped American justice for generations. The prison built for final sentences. San Quentin State Prison opened in 1852, making it the oldest prison in California. It was built on the edge of San Francisco Bay, where the water meets the land in a way that feels calm from a distance, but cold and isolated up close. Over time, San Quentin became more than just a prison. It became a name recognized across America. Not because it held the most inmates, but because it held something different. California's condemned. For decades, when a person in California was sentenced to death, they were sent to San Quentin. The prison became the central location for death row, where inmates were housed in small cells under strict control. The condemned population grew over the years. By the late 20th century, San Quentin's death row became one of the largest in the country. Many inmates arrived with death sentences that sounded final in court. But inside San Quentin, final often meant something else. Because once the gates closed behind them, the reality became clear. Executions were not quick. The process could take years, even decades, because of appeals, legal challenges, and changing laws. Some inmates spent so long on death row that they became old men inside the same walls where they first arrived as young adults. And as time passed, the prison's death row system started to face a new kind of pressure, not from inmates but from the outside world. Lawyers, courts, lawmakers, and the public began questioning whether California's death penalty system could even function as it was designed. Because by the time San Quentin held hundreds of condemned prisoners, California was facing a serious problem. It had death sentences, but fewer and fewer executions. And that raised a question that would haunt the prison system for years. Was death row still an active punishment, or had it become something else entirely? The waiting sentence. For many inmates on San Quentin's death row, the most frightening part was not a single day. It was the waiting. Because once a death sentence was handed down in a California courtroom, the public often assumed the next steps were automatic. Trial, conviction, sentence, execution. But inside San Quentin, the reality was far more complicated. Death row was not a fast path to the end. It was a system built on delays, appeals, legal reviews, and paperwork that could stretch across decades. And for the men locked inside those cells, time became its own kind of punishment. A place where time moves differently. San Quentin's death row units were designed for isolation and control. Inmates lived under strict supervision, often spending most of their time inside small cells with limited movement. Life was tightly scheduled. Every step outside the cell depended on permission, staffing, and security. The purpose was simple: to keep condemned inmates separated from the general prison population. But as the years passed, death row became overcrowded. California continued issuing death sentences throughout the 1980s and 1990s. The condemned population grew faster than the system could handle. Eventually, San Quentin held hundreds of death row inmates. And the more inmates arrived, the more the system slowed down. Why executions became rare. San Quentin was known as California's execution prison. But by the late 20th century, executions became less frequent. Not because California had stopped sentencing people to death, but because the legal process became longer and more complicated. Every death sentence triggered an automatic appeal. Defense lawyers challenged convictions. Courts reviewed evidence. New witnesses appeared. DNA testing became more common. And as public pressure increased, the courts demanded more strict procedures. This created a system where death row inmates could remain in limbo for decades, still sentenced to death but not close to execution. For prison staff, it created a different kind of responsibility. They were running a death row that was growing larger every year, even though the state was carrying out fewer executions. And this raised a serious question. If the state could not carry out the sentence, what exactly was death row becoming? The psychological weight of not knowing. Death row inmates at San Quentin lived with a constant uncertainty. Some fought their convictions. Some accepted their guilt. Some waited for a chance at reversal. Others waited for a date that never came. But one reality was shared by almost everyone. They did not control their future. They lived under a sentence that could change at any moment due to a court ruling, or could remain frozen for decades. This uncertainty affected everyone. Not just inmates, not just staff, but victims' families too. Because for families who had lost someone to murder, death row often felt like unfinished justice. The sentence was announced, but the closure never arrived. Some families supported executions. Others opposed them. But many agreed on one painful truth. The system moved so slowly that it kept reopening emotional wounds again and again. Every appeal meant another reminder. Another hearing. Another news headline. Another return to the past. And while the public debate continued, San Quentin's death row remained full. A place where people waited year after year for a final decision. A new execution method, a new controversy. For many decades, California carried out executions by the gas chamber. San Quentin's gas chamber became one of the most famous execution sites in America. But as legal standards changed and court challenges grew, California began shifting toward lethal injection. This transition was meant to modernize the process. But instead it created new legal battles. Questions arose about execution procedures, medical involvement, chemicals used, humane standards under the law. Every change in method led to more lawsuits. And those lawsuits caused more delays. The execution system became tangled in legal conflict. And as the delays grew longer, the death row population kept growing larger. San Quentin was now holding hundreds of condemned men, in a system that seemed increasingly uncertain about how to complete its own sentence. The turning point. By the early 2000s, it was clear that San Quentin's death row was no longer functioning the way it had been designed. California had the largest death row population in the country. But executions were rare. Appeals took decades. Costs increased. And legal challenges kept stacking higher. Then came the moment that changed everything. A wave of court decisions and legal scrutiny began to question whether California's death penalty process was even constitutional in its current form. And San Quentin, once the symbol of final punishment, was about to become the center of a much bigger crisis. Because soon the question would no longer be, when will the next execution happen? It would become something far more serious. Can California's death row system continue at all? The execution chamber that became a symbol. For decades, San Quentin's execution chamber was not just a room. It was a symbol. A physical reminder that California's justice system still held the power to carry out the ultimate punishment. Even people who never stepped inside the prison knew the name. San Quentin. Death row. The gas chamber. And later, lethal injection. But what most people did not realize was this. By the time San Quentin became famous for executions, California's death penalty system was already starting to break under its own weight. Because the execution chamber could not operate without the law. And the law was changing. The gas chamber era. San Quentin's gas chamber became widely known throughout the 20th century. It was built to carry out executions in a way the state believed was controlled and final. For years, the chamber represented certainty. A person sentenced to death would eventually face execution. But over time, the public began to see the gas chamber differently. Not as justice, but as something outdated, disturbing, and increasingly difficult to defend in modern courts. As legal standards evolved, challenges began appearing across the country. Lawyers questioned whether the method violated constitutional protections against cruel and unusual punishment. California was not alone in facing these questions. But because San Quentin was so well known, the attention often landed there first. And slowly the system began to shift. The move toward lethal injection. In the 1990s, California began preparing to use lethal injection as its main execution method. To the public, this sounded like the system was modernizing. But inside the courts, lethal injection became a new battlefield. Because the death penalty was no longer just about guilt or innocence. It was also about procedure. The state needed to prove that its execution process followed strict legal standards. Every chemical, every step, every medical roll became subject to review. And that review created delays. More lawsuits. More appeals. More hearings. Instead of speeding up the system, lethal injection became one more reason the process slowed down. And San Quentin, once seen as the final step, became something else. A place where the machinery of death existed, but rarely moved. A death row that kept growing. Even as executions slowed, death sentences continued. California courts kept issuing them. Prosecutors still sought them. Juries still delivered them. And each sentence added another inmate to San Quentin's death row. By the early 2000s, California had the largest death row population in the United States. Hundreds of condemned inmates. One prison. One system. But fewer executions than the public expected. This created a contradiction that became impossible to ignore. California had a death penalty system on paper. But in practice, it was becoming a long-term holding system. One that many critics said was expensive, unstable, and emotionally draining for everyone involved. The victims' families caught in the middle. For victims' families, death row often became a second life sentence. Every appeal brought back the same pain. Every court update reopened old wounds. Some families wanted executions to happen quickly. Others said they did not want the state to take another life. But no matter their view, many families shared one frustration. The system did not feel final. It felt endless. A legal process that moved so slowly it almost seemed frozen. For decades, California promised a punishment that sounded permanent. But the reality was that San Quentin's death row became a place where inmates waited and aged, while families waited for closure that might never come. The legal system tightens its grip. As time passed, federal courts and state courts increased scrutiny over California's death penalty process. The state was challenged over the length of time inmates spent waiting, the fairness of legal representation, the structure of the appeals process, the execution protocol itself. The more the courts questioned the system, the harder it became to carry out executions. California was not simply dealing with public opinion. It was dealing with constitutional law. And that meant the state could not move forward unless every step was legally defensible. San Quentin's execution chamber was ready. But the courts were not. And that gap created the next turning point. A system that looked like it was stopping. By the late 2000s and into the 2010s, California's death penalty system entered a period of deep uncertainty. Executions became extremely rare. Legal challenges over lethal injection procedures created long pauses. And the condemned population continued to grow. San Quentin became overcrowded. The cost of maintaining death row increased. And critics began asking a question that California could not avoid anymore. If the death penalty is almost never carried out, what is the purpose of keeping it? Because at this point, the punishment was no longer the execution itself. It was the waiting. And the waiting was starting to look like a punishment that the courts might not allow forever. The turning point. Then came the moment that changed everything. A legal and political shift began forming in California, one that would affect San Quentin more than any prison reform before it. Because the question was no longer about methods or appeals. It was about whether California would continue the death penalty at all. And soon, the state would face a decision that would shake the entire justice system. Should executions be paused indefinitely? And if they are paused, what happens to the men still living on death row? The moratorium, when California pressed pause. By the 2010s, San Quentin's death row had become a strange place in American justice. The condemned were still there. The execution chamber still existed. The sentences were still legal. But the system no longer moved the way people believed it should. California had created a punishment that sounded final, but in reality had become uncertain, slow, and constantly challenged in court. And then, in 2019, California made a decision that changed everything. The state did not abolish the death penalty. But it did something that felt almost as powerful. It pressed pause. A governor's order that stopped executions. In March 2019, California Governor Gavin Newsom announced a statewide moratorium on executions. This meant California would not carry out executions while the moratorium remained in place. The governor also took steps that made the pause real. He closed the execution chamber at San Quentin for the time being. He withdrew the state's lethal injection protocol. He halted plans for a new execution facility. This was not a vote by the public. It was not a decision by a jury. It was an executive action. And it sent a message to the entire country. California still had death row inmates, but it was no longer willing to carry out executions under the current system. San Quentin, the most famous death row prison in the United States, suddenly became something different. Not an active execution site, but a holding place for the condemned. A death sentence without an end date. For the men living on death row, the moratorium did not mean freedom. They were still sentenced to death. Their conviction still stood. But now the execution process was paused with no clear end date. For some inmates it created hope. For others it created confusion. Because the moratorium was not a legal reversal. It was a political decision. It could be changed by a future governor. So death row became even more uncertain than before. A person could live under a death sentence, but with no clear timeline for what the state would do next. In many ways the waiting became even heavier. Because the system now felt like it was trapped between two worlds. A death penalty that existed on paper. And a death penalty that did not operate in reality. The reaction: support, anger, and pain. The moratorium sparked strong reactions across California. Supporters of the decision said executions were too expensive, too flawed, too slow, too risky in cases of wrongful conviction. They argued that the system had become broken and unreliable. They believed the death penalty created legal chaos, not justice. But opponents saw the moratorium as something else. They saw it as a betrayal of victims. Many victims' families believed the death sentence was a promise made by the court. And when the state paused executions, it felt like the state was stepping away from that promise. For families who had waited decades, the moratorium reopened painful questions. Was the sentence ever meant to be carried out? Had the system simply created false hope for closure? And now that the state had paused executions, some families felt like their suffering was being extended again. San Quentin under new pressure. San Quentin's death row was already overcrowded. But now, the moratorium made it clear that the condemned population would likely remain there for many more years. This created new pressure on the prison system. Death row inmates were aging. Medical needs increased. Mental health concerns became more serious. And staff had to manage a unit filled with people serving the most extreme sentence possible, while the state had no clear plan for the future. San Quentin became a prison caught in the middle of a national debate. And the debate was no longer just moral. It was legal. Because the courts were also beginning to question whether California's death row conditions could be justified if executions were not happening. A new debate: is this still constitutional? Legal experts began asking a difficult question. If a person is sentenced to death but spends decades waiting without execution, does the punishment become something else? Some critics argued that decades of waiting could become a form of psychological punishment beyond what the law intended. Others argued the delays were necessary to prevent wrongful executions. And while lawyers and judges debated, San Quentin continued operating as the central location of California's death row. The condemned remained behind locked doors. The execution chamber remained unused. And the system continued to grow more uncertain. Then came the next turning point. As the moratorium continued, California began taking steps that suggested something even bigger was coming. Because the state wasn't just pausing executions. It was beginning to rethink how death row itself should function. San Quentin's death row units were aging. Conditions were being criticized. And prison leadership started looking at major changes. The question was no longer only about executions. It became about the prison itself. Because San Quentin was about to undergo a transformation that few people expected. A plan to dismantle the traditional death row structure and move condemned inmates into a different kind of prison system. And that meant the story of San Quentin's death row was entering a new era. One that could permanently change what death row means in California. The end of death row as the world knew it. For most of modern American history, death row was designed to be separate. A condemned inmate was not treated like an ordinary prisoner. He was placed into a special system, often isolated, tightly controlled, and kept apart from the rest of the prison population. At San Quentin, that separation became part of the prison's identity. Death row wasn't just a housing unit. It was a world of its own. But by the early 2020s, California began moving toward a decision that would reshape that world completely. Not by ending the death penalty through law, but by changing how death row inmates would live. The plan to dismantle San Quentin's death row structure. As the moratorium continued and executions remained paused, California officials faced a reality they could no longer ignore. San Quentin's death row units were old, overcrowded, and difficult to manage long-term. The state began shifting toward a policy that allowed death-sentenced inmates to be housed under less restrictive conditions, depending on their behavior and security level. In simple terms, California began moving away from the traditional idea of death row as permanent isolation. Instead, officials started considering a system where condemned inmates could be integrated into different prison housing environments, rather than kept in one lockdown unit for decades. This was a major turning point, because for generations, death row at San Quentin had represented one thing: final separation. Now that identity was beginning to fade. San Quentin's death row becomes a political and moral battlefield. By this point, San Quentin was no longer just a prison. It was the center of a national argument. Supporters of reform argued that the old death row system had become meaningless because executions were not being carried out. They believed the prison system needed to focus on safety, stability, and humane conditions, especially for inmates who might spend their entire lives incarcerated. Critics argued the opposite. They believed that changing death row conditions weakened justice and disrespected victims. To them, death row was supposed to be harsh because the crime was harsh, and they feared that California was slowly dismantling the death penalty without ever admitting it directly. In their view, the state was avoiding a clear decision and replacing it with quiet policy changes. The reality: California's death penalty still exists. Even after the moratorium and reforms, one fact remained true: California's death penalty was still legal. Court sentences still stood. San Quentin still held condemned inmates. But the public began to realize something that many had not fully understood before. A death sentence in California did not always mean an execution would happen. Instead, for many inmates, death row had become a different kind of punishment. A punishment built around uncertainty. A punishment shaped by time, not procedure. Some inmates would die of natural causes before their legal process ended. Others would spend decades in appeals. Some would have their sentences overturned. Some would remain condemned with no clear future. San Quentin, once known as the place where the state carried out death sentences, had become something else. A prison filled with people serving the most severe sentence in law, while the state itself seemed unsure how that sentence would end. The last walk wasn't always to the chamber. San Quentin's death row has been called many things: a symbol of justice, a symbol of punishment, a symbol of fear, and for many, a symbol of a system that America still cannot fully agree on. For decades, people believed that the last walk meant one final trip down a corridor toward execution. But the real history of San Quentin reveals something more complicated. In California, death row often became a long sentence of waiting, sometimes longer than the public could imagine. Not just for inmates, but for victims' families, for prison staff, for lawyers, for judges, and for a state caught between law, politics, morality, and public opinion. San Quentin reminds the world that the death penalty is not only about punishment. It is about systems. It is about whether a government can carry out the most final sentence responsibly, fairly, and consistently. And California's story shows what happens when that system slows down until it almost stops. Because in the end, the darkest reality of San Quentin's death row may not be the execution chamber. It may be the fact that for decades, hundreds of people lived under a sentence of death, while the state struggled to decide what that sentence truly meant. If you found this documentary informative, make sure to like the video, subscribe, and turn on the notification bell for more real prison and crime documentaries. And comment below: do you think the death penalty system can ever be fair, or does it create more suffering for everyone involved?